Good afternoon and welcome to the International Justice Day webinar, which is being hosted by Doughty Street International. My name is Kirsty Brimelow and I'm a QC at Doughty Street Chambers and part of the international team. And we have a very exciting and I'm sure extremely informative panel that is going to be speaking to us over the next hour. And it's also an interactive session. So please do put in any questions that you have and start doing it at any point. So if you can put it in the Q&A and or the chat, then it means that your questions can be considered and it gives all our speakers chance to. I'm going to move on to introductions whilst appreciating that probably none of this panel does actually need an introduction. I'm going to do it all the same. Our first speaker is Sir Howard Morrison QC. And he has an interesting background in terms of his career as a barrister. He was called to the bar by Gray's Inn, and in fact is a bencher at Gray's Inn, and he was called to the bar back in 1977 and then practiced for 10 years in common law and moved to Fiji to be a resident and then chief magistrate. And then he moved into other areas of international law before the main tribunals. So he worked defending in the ICTY and then the ICTR, and then subsequently took silk and became a senior circuit judge, moving to Cyprus as a judge of the STL, and then a judge at the ICTY, where he is very known for the trial of Radovan Karadzic. He was then elected the UK judge to the ICC, where he served as president of the Appeals Division. He is a senior fellow of the Louchipact Centre at Cambridge University. And he also is a visiting professor of Northumbria University and lectures worldwide on international law. Our next speaker is a new associate tenant, as is Howard, at Doughty Street International, and is Fergal Gaynor. And Fergal Gaynor is qualified and practiced at the Irish bar and became a judge of the Kosovo Specialist Chambers in The Hague, the Reserve International Code Prosecutor at the Extraordinary Chambers in the Courts of Cambodia. He, over his career of some 20 years, has investigated and prosecuted senior members of the Bosnian Serb leadership, the Khmer Rouge leadership, the interim government of Rwanda, and Syria's security and military leadership. And at the ICC, he acted as lead counsel for groups of Kenyan, Afghan, and Palestinian victims. And finally, but by no means least, a barrister at Doughty Street Chambers is Peta-Louise Bagott, and she practices in international law, criminal law, and her international practice includes defending in numerous high-profile cases at the ICC. She's recently represented Ratko Mladic on appeal, and she's worked on cases at the ICC, ICTY, IRMCT, RSCSL, and also is a barrister who's been granted leave in amicus curiae in cases on appeal. And so welcome to all, and the session is being recorded and you'll have received the box asking for your permission. Obviously, if you don't in any way wish to be recorded, or for your names to be submitted when it comes to the Q&A, please again put that in the chat. It probably for our audience is only going to apply to the Q&A. If you want to keep your identity to yourself, obviously you're perfectly entitled to do so. Final bit of housekeeping from me is that my internet connection, not being in a strong internet zone at the moment, is a little unstable. And so when it comes to the Q&A, this might be more or less the last that you see of me, and I might then go into my own disguise, although not really, because obviously everybody knows what I look like, but I might turn my camera off, so no rudeness intended. Therefore, with welcome to all of our panel, we're very excited in particular to welcome Fergal and Howard as our new associate tenants at Doughty Street Chambers, and for them to be joining our international team. We're very privileged to have them joining us and lending their expertise to us. And so that's probably enough from me now. If I may hand over to Sir Howard Morrison QC. Thank you.
Thank you very much, Kirsty, and thanks to Doughty Street Chambers and all the attendees on what I gather is going to be the hottest day of the year in the UK so far. The first thing I want to deal with is the selection of judges for the ICC. What is actually an enormous relief is that up until now, when I was a serving judge at the ICC, I always had to preface any comments I made that I wasn't speaking on behalf of the ICC. The views were strictly mine alone, etc., etc. Well, I'm not speaking on behalf of the ICC, and the views are mine, but there's a great deal less constraint when you've stopped being a full-time judge. And so you venture into things which are slightly more contentious and perhaps even political, and I make no excuses for doing so. Selection of judges for the ICC is something I've been concerned about following my own experience during the election campaign that I went through. I think endured is a better word, and thereafter. And it's very hard to accept that the Assembly of States Parties has any grounds for criticising the ability of judges who end up at the ICC, as they, as individual states, select and promote the candidates and then collectively elect them. So the judicial body is very much a creature of the Assembly of State Parties making. The way it's done is, I think, seriously flawed and needs to be revisited. It's seriously flawed in the sense that the election campaign is really it's a horse trading exercise. A lot of things go on behind the scenes, with one state promising to vote for another state's candidate if the other state will vote for their candidate for another position in another court or tribunal or institution. And it's perfectly apparent that this goes on. In fact, there's very little secret made of it. And we also have what are called judges from the A list and the B list. I find that particularly difficult to justify. There should only be one list of judges, and people who are applying to join the world's most senior international court ought to be coming from a background of judging, extensive judging at that. I mean, when I was a defense counsel at the ICTR in Arusha in Tanzania, you were telling defense counsel that they couldn't be lead counsel until they'd had 7 years of experience as counsel. And yet nobody was suggesting that any of the judges needed to have 7 or any years experience as a criminal judge, as long as they passed the test. Now, there was more, I think, focus on having judges at ICTY and ICTR who came from a very solid judicial background. But at the ICC, you can have people, and you do have people, sitting as judges who come with no judicial background at all. They may be prosecutors, they may be academics, they may simply be diplomats. But it seems to be unjustifiable that you have people appointed as judges and require them to work in very demanding cases with no active judicial experience at all. So the first thing I think ought to happen is that the rules should be changed to mandate that all candidates come from a strong judicial background. And my replacement at the ICC, Joanna Corner, certainly does that. But more importantly, perhaps, or at least as importantly, we need to do away with the election as it is. When you go for the election, you go off to and you sit in what's called the Indonesia Lounge, the main United Nations building in New York, although the ICC is not a UN court. And you are literally interviewed for several days, perhaps 10 or 15 times a day by groups of people. And you try and sell yourself as a potential judge or candidate to them. It's to some extent demeaning, but it's also very unsatisfactory because the people who are interviewing you are essentially diplomats and representatives of their country in New York. They're not judges, and whether they know the skills that judges should have and should be looked for is debatable. So what I would say is that there ought to be an independent Judicial Appointments Commission set up, entirely independent of the ASP, whose job purely is to examine the candidates that the individual ASP states has put forward and to select them on judicial merit. Now, this isn't rocket science. Judicial Appointments Commissions are well known the world over in many domestic, in fact, all domestic jurisdictions. So I can't see why it cannot be done, save and except that the ASP is very reluctant to let go of this control of the judicial body. In one sense, I understand that. In another sense, they have to sit back, having done so, and accept the responsibility for the judges which they have elected. And if some judges prove not to be up to the mark, then it's not the fault of the individual judge, it's the fault of the people who put them in that position. And I always used to say to students several things. The ICC is not a human rights institute, although it's very much human rights based. It's not a PhD factory, it's not an employment agency, and it's not a training ground for ab initio judges. It's a unique senior criminal court. Needs to be staffed as such. If that sounds like a litany of complaint, then to some extent it is. But really, getting the best possible judges into the court is a matter of extreme importance. I'd like to move on now to another topic, which is the concept of ecocide as an environmental crime. Or at least environmental damage being treated as a criminal offence. The concept of ecocide as an environmental crime, it's not a new word at all. It's something that people have perhaps only just heard about, but in fact it first was used in the 1970s after the use of Agent Orange in Vietnam, the defoliant that was deliberately sprayed and has caused immense problems for the citizens who were affected by it. Over the years since then, there have been many who have attempted to promote the concept of ecocide or environmental crimes at the United Nations and in individual states. But we're short on time and I can't deal with all of those worthy attempts. But suffice it to say, there is only one provision in the Rome Statute, which is in fact related to war crimes, which explicitly mentions damage to the environment per se, and that's Article 8(2)(b)(4). And that is the only direct example of where the environment is put forward as a if you like, a victim. In 2010, the late Polly Higgins, who was a very, very persuasive advocate for criminalizing environmental crimes, and I was privileged to meet, she died very, very young, proposed that the Rome Statute be amended to include ecocide to become the 5th international crime against peace. We, of course, have genocide, which is a crime against humanity, but has a standalone significance, mainly because of the requirement for a specific intent. Crimes against humanity, including, as we know, the catalogue of crimes immediately recognized in any domestic jurisdiction: murder, rape, torture, etc. War crimes, which are, of course, the international humanitarian law by and large, and the more recent crime of aggression. To add to those 4, ecocide is to make the environment, as it were, and the correlation between people and the environment the victim. Protecting the environment cannot be but protecting humans too. The nexus is obvious. In fact, 10 countries have codified ecocide in their domestic laws, and happily, many are ranked highly for corruption and very low for respect of the rule of law by Transparency International. But hope is at hand. In November 2020, a panel chaired by Professor Philippe Sands of University College London and the Zambian judge Florence Mumba, who I was a colleague of at the ICTY, started drafting the proposed law I expect you are all actually well aware of. On June 22nd this year, the Stop Ecocide Foundation submitted a formal definition for ecocide to the ICC to create a global legal precedent. And in terms, it's this: any unlawful and wanton acts committed with the knowledge that there is a substantial likelihood of severe and widespread or long-term damage to the environment. Now, that is a very important progression and very welcome progress. But also the category of crimes against humanity is never closed. And if environmental damage is going to cause egregious harm to a group of people, an inventive prosecutor may seek to put that forward as a basis for prosecution. I don't see that that is beyond the wit or the scope of the Rome Statute. In crimes against humanity, human harm is a prerequisite. Under ecocide, it's not. It's the damage to the environment, but of course from that flows harm to the flora, fauna, including Homo sapiens. But what it means is that not only are we changing the content and architecture of the Rome Statute, but also to some extent expanding the mandate of the ICC away from just the human perspective. But we need to consider what needs to happen to amend the Rome Statute and adopt ecocide as a specific crime. Firstly, a member state of the ICC would have to submit a definition to the UN Secretary General. Secondly, the proposal must then be voted on by a majority of the Assembly of State Parties in their annual assembly, normally in December of each year, to be considered. Once a final text is agreed upon, it's then necessary to achieve the vote of 2/3 of the member states of the ASP to vote in favor of it to trigger an amendment to the Rome Statute. It would need then to be ratified by member states and become a criminal offence in such states. And ratifying members could also arrest non-nationals on their soil for ecocide crimes, environmental crimes committed elsewhere. All this is wonderful, and one hopes it comes to pass. But at this stage, if such a crime comes onto the statute book of the Rome Statute, I can see, to paraphrase Shakespeare, enter Trump et al. Stage right. Far right, because the complaints will be manifest and the opposition to it will be manifest, not least because a lot of environmental crimes are caused by massive corporations. I'm not ranting against massive corporations. I'm simply ranting against those who do not take the care of the environment as stewards of the environment that they should. Now, it's a long road, but major steps have been taken, so watch this space. I'd like to conclude what I'm going to say now by looking more to the future and to see what is coming. Everybody knows how political things can be at the ICC. I have always said you can't stop the politics behind every situation at the ICC. What you can stop as a judge and what you must stop as a judge is that those politics do not come into the courtroom or play any part in the decision-making process, either in the pre-trial stage or the trial stage or the appeal stage. And that comes down to the integrity and the strength of the judges concerned. There are a number of things that we're looking at for the future which are intrinsically linked. Pollution and climate change, diminution of resources, not least water, overpopulation and increased demand for the diminishing resources, the destruction of the ocean habitat or the pollution thereof, and the natural flora and fauna. Now, all of those things are interlinked. They affect the planet and they affect us and they affect every living creature and plant on the planet. It is of enormous consequence. Ever since man became societal, we've found an excuse to have a war, whether they were wars of pure greed, they were theological, philosophical, economic, or simply competing social and economic theories, like the war between communism and capitalism that was at least the Cold War that dominated politics for so long. But I see new causation for conflicts coming up. I've already mentioned water, but I think water is a critical one. Water is the one thing that everybody needs. We need it for agriculture, we need it for domestic consumption. And the provision of clean, potable water is for many years been a terrible problem in parts of Africa and South America and other countries. And most of the diseases that infant children die of in Africa, for instance, are waterborne pathogens because they don't have access to proper drinking water. And if the provision of those resources diminishes even further, it is inevitably going to give rise to conflicts, whether it's one nation damming a river upstream of another, or simply overconsumption. And one doesn't have to look very hard to see what the lack of water causes. If you look at the situation in Djibouti and Yemen at the moment, the lack of water is a major source of conflict, major source of famine, and people are having to buy water at great expense. And these are people who cannot afford to do so. It is absolutely critical. And so conflicts are going to arise. And as with anything, conflicts are going to be resolved in one or two ways, either by law or war. And of course, we want it to be such conflicts to be resolved by law in properly constructed courts and tribunals, and with the architecture of law, particularly international law, being fine-tuned to be able to deal with it. Because side winds will blow. If, for instance, rising sea levels, let me take Bangladesh as an example. The floodplains of Bangladesh, or the sea plains of Bangladesh, which are virtually at sea level, support a very huge population who live and grow their crops on that land. A 10-centimetre rise in sea level will inundate that land with salt water, be no use for agriculture, no use for living on. And what you're going to have is migration on a massive scale. And so from that will flow changes to asylum law, to migration law, to refugee law, which is also going to, the architecture is also going to have to change to accommodate it on an international scale. So we're going to have to rethink a lot of things for the future if these environmental problems continue. And the basic problem may be one that we can't do anything about, which is overpopulation. I mean, seems to me to a virtually insoluble problem at the moment, but the consequences of that are things that we're going to have to look at. So this is what I see coming up in the future. International law, the architecture there is going to have to change. And who's going to be changing it? Well, I'm thinking about the audience that we have here. You are. Young people, you are the future. You are the hope for the future. Young, bright, persistent and resilient young lawyers is what we need. Never give up. Determined persistence prevails. We can overcome these problems. We just need the will collectively to do so. Thank you very much.
Thank you very much, Howard. And Fergal, if I can now hand over to you, please.
Thank you very much indeed, Kirsty, and indeed to Howard for his excellent presentation, and to Peta and Julie and all of those who organised today's event. Today's the 23rd birthday of the Rome Statute of the International Criminal Court, and I want to address 4 aspects of the rule of law which are of particular relevance. I owe an immense debt to Lord Bingham's inspiring book, The Rule of Law, from which I have liberally borrowed ideas and examples. I fully share his vision of a world in which every society is governed by the rule of law in the interests of good government and peace at home and in the world at large, as he said. Now, the UK has seen a spirited debate, particularly over the last 20 years, about the relationship between the rule of law, human rights, and civil liberties on one hand, and security against terrorist attack on the other. The rule of law continues to be invoked by both sides in some of the most contentious issues of the day, such as whether it is in the UK's interest for Parliament to override the UK's treaty obligations, and what to do when prosecutors are faced with obstacles in securing convictions for murder and other serious crimes related to the troubles in Northern Ireland. I believe that the passionate and sincere debate in the United Kingdom on these questions has much to offer international criminal justice. The 4 aspects of the rule of law that I propose to address are: first, ensuring that the law is adequately accessible; second, respecting the independence and impartiality of judges and prosecutors; third, ensuring compliance with treaty obligations, including the dispute resolution provisions of treaties such as the Rome Statute; and fourth, applying the law equally to all, without adverse distinction on grounds such as nationality or religion of perpetrator or victim. First of all, international criminal law must be accessible, intelligible, clear, and predictable. That is to say that the ordinary person must be able to know, if necessary with professional advice, the legal consequences of his or her conduct. The Rome Statute, the rules of procedure and evidence, and the elements of crimes are well drafted and available in the 6 official languages of the court. Whatever ambiguities or gaps they contain, overall they do meet the standard of accessibility. But the coherence of judgments which are emerging from the ICC is a cause of concern. A recent independent expert report cited the example of the decision to acquit Laurent Gbagbo and Charles Blé Goudé. A motion for no case to answer was filed in July 2018. Nearly 6 months passed before the trial chamber orally gave a relatively brief decision to acquit by a majority of 2-1. The written judge of the dissenting judge was filed at the same time. 6 more months elapsed before the 2 judges in the majority filed their written reasons to acquit. The reasons by one judge ran to 90 pages and by the other to 960 pages. At the appeals chamber, it has sometimes been difficult to assess what exactly has been decided. A 3-2 majority decision is of course easy enough to follow, but as the independent experts noted, some issues have been decided by the 5 judges on a split of 2 to 2 to 1. We have heard from Howard some of the reasons behind this, and it seems fair to say that we can improve the speed and concision of decision making at the ICC. Of course, extreme speed and extreme brevity are not what we are after. Lord Bingham referred to the case of a defendant who was convicted of theft at the Old Bailey in the 1840s after a trial which lasted 2 minutes 53 seconds, and that included an economical jury direction. Gentlemen, I suppose you have no doubt, I have none. But everyone agrees that international criminal proceedings can and must move faster, and this forms a core part of the much needed reform process which is underway at the ICC. I see much value in Bingham's observation that the principles of law decided by the majority should be clear and rendered within a reasonable time. There's nothing wrong with dissenting opinions on point of law, as these help in the overall development of the law, although in my view, dissents should be concise. Radical changes in how the law is applied should be avoided. As Bingham argued, the law should be improved incrementally. It is one thing to move the law a little further along the line on which it is already moving, or to adapt it to accord with modern views and practices. It is quite another to recast the law in a radically innovative or an adventurous way, because that is to make it uncertain and unpredictable. Certainly, enormous and unexpected changes by judges in the procedural landscape can be antithetical to the rule of law, but as Howard pointed out, the challenges of climate change and access to water are real and urgent. As for factual findings, international judgments inevitably concern complex and highly contested events, and sometimes vast campaigns of persecution or genocide. They are important not just for establishing in clear terms whether the accused is guilty of the crimes charged, but also for the survivor's right to know, and for remembering the murdered, as well as those who resisted the tide of evil. International criminal courts bear a special responsibility to ensure that their contribution to the collective memory of mass atrocity is objective, clear, and accessible. Trial and appeal judgments therefore cannot always be short, but they must be written in a manner which brings their factual findings to the victims and to the public at large in an accessible way, thus enhancing reconciliation, deterrence, and understanding of international criminal justice. The second principle of the rule of law that I want to address is the independence and the impartiality of judges and prosecutors. It is universally accepted that in order to be effective, judges and prosecutors must be completely free of political interference and must act with true independence and impartiality. This is particularly important at the ICC for two reasons. First of all, as we've just heard from Howard, candidates for judge and indeed prosecutor usually receive backing from their own state and run what is in effect an election campaign in order to get the votes of enough states to get appointed. And horse trading, as Howard pointed out, does take place. The concept of judges and prosecutors running election campaigns is of course utterly alien to many domestic systems. Second, perceptions of bias are particularly acute in international criminal justice. In my experience, it is common for international judges and prosecutors to be portrayed totally unfairly by opponents of the court as biased for or against a particular ethnic or religious group. In light of this, it is particularly important that judges and prosecutors, once elected, make an extra effort to show that they are completely free of political control and direction in their treatment of the situations and cases that come before them. To me, impartiality and independence in international criminal justice, as in domestic justice, is a test of character more than anything else. What is required is the strength of character to put all considerations aside, except the law and the facts in the case at hand. As Bingham said, judges must be independent of government, vested interests of any kind, public and parliamentary opinion, the media, political parties and pressure groups, and their own colleagues, particularly those senior to them. As is well known, there have been determined efforts to persuade ICC judges and prosecutors to depart from the statutory requirements of independence and impartiality. Perhaps the best known of these was the executive order by President Trump, which sought to impose visa restrictions and asset freezes on ICC prosecutors and judges in order to persuade them to carry out their functions under the statute in a particular way. Thankfully, a large number of states parties and civil society rallied to the court's defense, and the Biden administration has rescinded that order, that executive order. Full frontal assaults on the courts such as this are primarily for domestic consumption, but there will always be a danger that states will attempt quietly and indirectly to persuade judges or prosecutors to act in a manner inconsistent with the statutory obligations of independence and impartiality. It is of cardinal importance that these efforts are resisted. The third principle is that states must comply with obligations in international law, which Lord Bingham considered to be a fundamental principle of the rule of law generally. It should be uncontroversial to say that a state must comply with its treaty obligations, and if it sees a difficulty in complying with any particular obligation, it must use the dispute resolution mechanisms set out in that treaty to try to resolve the issue. But this has been the subject of vigorous debate in the UK recently, and I believe that we can draw lessons from that debate for international justice. When Bingham wrote the rule of law in 2010, the ministerial code, which is binding on British ministers, required them to, as an overarching duty, to comply with the law, including international law and treaty obligations. The current version merely requires ministers to comply with the law. The obligation to comply with international law and treaty obligations was deleted in 2015. The Court of Appeal in 2018 ruled that that particular deletion did not involve a change of substance, as the government had repeatedly and publicly clarified that the obligation in the ministerial code to comply with the law included the obligation to comply with international law. This debate heated up again on the 8th of September last year, when the Secretary of State for Northern Ireland was asked to confirm whether a piece of proposed Brexit-related legislation does or potentially might breach international legal obligations or international legal agreements. The Secretary of State replied, yes, this does break international law in a very specific and limited way. In an accompanying statement, the UK government stated, it is an established principle of international law that a state is obliged to discharge its treaty obligations in good faith. This is and will remain the key principle in informing the UK's approach to international relations. However, in the difficult and highly exceptional circumstances in which we find ourselves, it is important to remember the fundamental principle of parliamentary sovereignty. Reaction to all this was swift and fairly fierce. The chair of the Bar Council, Amanda Pinto QC, said, we share widespread concern about the government's stated intention to break international law. It should not need to be said that this country is built on and subject to the rule of law. Undermining this vital principle will fatally puncture people's faith in our justice system, both at home and internationally. Someone committing a crime in a specific and limited way nonetheless commits a crime, and an admitted breach of international law in a specific and limited way is nonetheless a breach. Former Prime Ministers John Major and Tony Blair co-authored an article in which they said, if Parliament deliberately passes legislation known to undermine international law, what will that do to the reputation of Parliament and our nation? For a country that has for hundreds of years furthered the cause of law around the world, respecting treaty obligations is just as important as domestic law. Another former Prime Minister, Theresa May, asked in the House of Commons, how can the government reassure future international partners that the UK can be trusted to abide by the legal obligations of the agreements that it signs? Now, in this debate, the duty to comply with international obligations was framed primarily as a pragmatic issue, one of self-interest. It was a recognition that it is essential to the UK's own interests that it complies with the agreements that it signs. And it has signed many. The Foreign Office maintains a public online database of the UK's obligations under over 14,000 treaties to which the UK is or has been a party. And Professor Vaughan Lowe has observed that it is a myth that international law is more honoured in the breach than in the observance. He said, this view, particularly widespread among those whose vision is unsullied by any knowledge or experience of the matter, is hopelessly wrong. And I think he's right. As ordinary life returns, when it does return after COVID, a British citizen of average income can expect to be able to book a cheap flight on an Irish airline, to fly on an American plane through French airspace, to drink Mexican beer on a Spanish beach while watching a Norwegian drama on a Korean smartphone manufactured in Vietnam. All this depends on compliance by governments around the world with a multitude of agreements regulating the carriage of goods and persons by air, sea, road, and rail across borders, not to mention the web of agreements that regulate international trade over the internet. Every day, millions of people and billions of pounds worth of goods, capital, and services move quickly and smoothly around the world, thanks to compliance with international treaties. And national security depends enormously on compliance with international agreements that regulate intelligence sharing, extradition, and much else. Our way of life, our prosperity, and our security is possible only because states understand that it is in their own interest to comply with their obligations under a vast web of international agreements. It follows that steps deliberately taken to breach treaty obligations weakens this system, which is so beneficial to all of us. Weakening that treaty system would directly weaken the global prosperity and security that so many, not everyone, enjoy. It would weaken the fight against climate change, the most important challenge of our age, which relies completely on international cooperation. Turning to international justice, too often we see treaty obligations ignored. We hear arguments to the effect that international justice is all well and good, but frankly, we must think about national security. National security trumps accountability, we're told. Often, complementarity is invoked, even where there are clear indications of the unwillingness or inability of the state at issue genuinely to investigate or prosecute. To me, the choice between national security and international justice is a false choice. National security, and indeed commerce and prosperity, flow from a sense of justice in the affected population. Look at the root causes of any conflict you care to name, and you will find that if the affected population feels that they are victims of unfairness, a breeding ground for terrorists and extremists with resultant instability and violence is far more likely to emerge. The former Attorney General for England and Wales, Dominic Grieve QC, in 2013 spoke of Northern Ireland at the start of the Troubles. And Dominic Grieve said, the vital quality of fairness was missing, and this fueled resentment, anger, and hatred. Where did this lead? To almost 4 decades of bloody conflict, instability, and violence. The government reacted, usually from the best of motives, but all too often oppressively and in reality beyond the rule of law. There was, for example, imposed a system of internment, imprisonment without trial. This was a system perceived as biased, unfair, and unjust. It further fueled the anger and hatred and proved to be a fertile breeding ground for terrorism and discontent. Dominic Grieve said, if you undermine or subvert the rule of law, in the belief that by so doing you will protect your regime or system of government, you will ultimately prove to be the destroyer of all that you seek to preserve. Now, I believe that the same considerations articulated so clearly by Dominic Grieve apply to international criminal justice. In the aftermath of atrocity, the affected population must be provided with convincing evidence that those most responsible have been held accountable. A major international trial provides a dignified forum in which thousands of documents produced by the persecuting authorities themselves are examined. and the evidence of hundreds of insider and victim witnesses is heard. As I mentioned earlier, the primary aim is, of course, to determine whether the accused is guilty or not of the crimes charged. But the process inevitably helps to reveal the truth about highly contested events. This in turn lessens the appetite for violent revenge and enhances the prospects for reconciliation. With more reconciliation, there is greater stability. And with greater stability, there is greater national, regional, and international security. A fair system of international justice therefore reinforces rather than threatens national security. And compliance with treaty obligations under the Rome Statute is part of reinforcing this fair system of international criminal justice. Recently, we've seen indications by a couple of states parties that they consider themselves to be bound by the Rome Statute to cooperate only in respect of investigations that they happen to agree with. This is a worrying tendency, and it requires a response. First of all, states parties with grievances against the court should be encouraged to air those grievances within the structures contained in the Rome Statute. The statute makes generous provision for procedures to address difficulties which might prevent a state party from complying with its treaty obligations due to the existence of a pre-existing treaty obligation undertaken with respect to another state, or where a request for assistance would require the requested state to act inconsistently with international law, or where the execution of a particular measure of assistance is prohibited in the requested state on the basis of an existing fundamental legal principle of general application. Secondly, states are on occasion invited to make legal submissions in specific proceedings, and they have filed submissions. For example, 8 states, as well as the League of Arab States and the Organization of Islamic Cooperation, filed written arguments on the question of whether Palestine can be considered to be a state party. I firmly believe that this trend should be encouraged. States, whether or not they're parties to the Rome Statute, should be actively encouraged to take advantage of the numerous opportunities they have under the Rome Statute to make their legal objections clear and to appeal adverse rulings. And where 2 or more states parties differ in their interpretation of the statute, they shouldn't hesitate to use the dispute resolution mechanism set out in Article 119, which leaves open the possibility of referral of a question to the International Court of Justice. What is not acceptable, in my view, is for states parties to refuse to cooperate with the court in respect of a particular situation due to a dispute about jurisdiction, and to refuse to use the dispute resolution provisions in the statute. For any party to fail to adhere to dispute resolution provisions in a treaty that it has voluntarily signed is contrary to the rule of law. As Lord Bingham said, the moment that a state treats the rules of international law as binding on others, but not on itself, the compact on which the law rests is broken. The fourth and final principle I want to discuss is equality, by which I mean applying the Rome Statute equally to all, without adverse distinction on grounds such as nationality or religion, of perpetrator or victim, and without adverse distinction to any state party. The prohibition of adverse discrimination is a principle of the rule of law which is well entrenched in domestic systems. We all accept that some categories of persons, such as children, the mentally ill, and prisoners, are treated differently because their position is in some important respect different. But the days when British law, for example, not only tolerated, but imposed, and the courts upheld, disabilities on women, Jews, Roman Catholics, and homosexuals are long gone. It is in the application of criminal justice that significant difficulties continue to arise, as the Black Lives Matter movement makes clear. However, it seems to me that the international criminal justice system is some way behind in all of this. One continues to hear high-level statements which disregard the strict requirement that every person who has committed or who has been the victim of a Rome Statute crime on the territory of a state party be treated without adverse distinction on grounds such as race, color, language, religion, political or other opinion, national, ethnic, or social origin. We can't simply dispense with the Rome Statute's clear prohibition of discrimination. It must be fully respected by all. Similarly, we must respect the fact that the Rome Statute recognizes only one category of states parties. The statute imposes duties and confers rights on every state party without exception. The statute doesn't foresee a situation where a state party does not fully enjoy its rights under the statute. The sole exception to this is that the United Nations Security Council, which of course has 5 veto-wielding permanent members, including France and the United Kingdom, can at any time refer a situation to the court or can defer for 1 year an ongoing investigation or prosecution. But in all other respects, the 123 states parties are equal. The Rome Statute belongs to each of them. We cannot allow a perception to emerge that some states parties to the statute are more equal than others. In conclusion, the choice between the rule of law and national security is a false choice. The choice between international accountability and national security is also a false choice. National, regional, and international security are enhanced and strengthened by support for international justice mechanisms, which help to reinforce stability in post-conflict environments. The focus must be on strengthening the court by respecting the rule of law and giving the court the resources that it needs to carry out its mandate under the statute. Collectively, we spend on all international justice mechanisms much less than 0.1% of what we spend on keeping and equipping armies, navies, and air forces. Yet the security benefits which flow from robust and fair international justice processes are significant. We must be more assertive in promoting respect for the rule of law in international criminal justice as a means of reinforcing our own security. Thank you very much indeed.
Thank you very much, Fergal, for that very thoughtful. With Howard's talk will have inspired some more questions. We're getting some coming through. I encourage everybody, please, to any questions, any comments, and then we'll be able to reach them. It is an interactive session. Thank you very much. If I can hand over now to Peta-Louise Bagott, please. Thank you.
Good afternoon, everyone, and thank you again for joining us today. Although it's one of those rare sunny days in London, I hope you'll agree that the keynote speeches were well worth staying indoors for. Howard and Fergal have highlighted some of the institutional and legal challenges international law faces. I'm going to try and give you an insight into the life of a junior barrister doing ICL work, and also set out some of the opportunities that are out there for you to get into this field. Before I tell you about working in ICL as a junior, I think it's important for you to know a little about me. The reason being that I've sat through many a talk from junior practitioners about how they got into the field and the work they were doing, and it all felt as though it was so far out of my reach. I would listen to them and feel so disheartened. So, full disclosure, I have applied for all sorts to try and get a foot into the door, even roles with the most tenuous links to ICL because I was desperate. I've received many, many, many rejections. And there are even some applications that I'm still waiting to hear back from today. Although I think after all these years, we can safely assume that I've been rejected. My route into ICL was via an application for a role that I was not qualified for. Having received countless rejections, I saw an advertisement for a role at the ICTY. And the way the advertisement was pitched is that they were looking for someone who spoke Bos, Croatian, Serbian to join the defense teams. I don't speak Bos, Croatian, Serbian. But a friend of mine said, "What have you got to lose by applying?" So I did. In the application, I glossed over the fact that I didn't speak BCS, and I highlighted the things that I could do. And after I hit send, to be honest, I forgot about it. I didn't hold much hope. But 2 weeks later, I was offered a position on the Mladic defence team. And as they say, the rest is history. As a junior on an international team, the bulk of the work, depending at what stage you're at, will be drafting. Drafting is a key skill for practitioners. So much work is done on paper, whether it's motions or written submissions, or at the appellate stage, drafting the grounds of appeal, that you have to feel comfortable doing it. And depending on your role within the team, you may also be asked to manage the day-to-day running of the team. A normal team setup, you'll have counsel and co-counsel, supported by legal assistants, case managers, investigators, and interns. So generally, there's a lot of people. Now, certainly as a junior, you could be the person that is responsible for linking the two halves of the team together. Effectively, you have to report up and down, as well as keeping on top of everything and reporting into counsel. Part of that role will be managing tasks, delegating tasks, ensuring that counsel has everything that they need, for instance, for a cross-examination. But it doesn't mean that that's your only role. You'd still be expected to engage with the legal issues and also the factual issues, providing assistance to counsel for cross-examination points, for example, be it the preparation of bundles or be it working through certain elements that need to be dealt with. In large teams, it's often the case that the crime bases in particular are divvied up. In a case, for instance, such as Mladic, there was so much material, there were so many crime bases that people had responsibility for certain areas and then used the hive mind when it came to the actual application of it. So your role is more than just paper pushing. It will be an active role, albeit behind the scenes. In terms of advocacy, this will very much depend on your team setup and your experience. Legal consultants and legal assistants can be granted rights of audience to enable them to make submissions or cross-examine witnesses. In most teams, it's about the experience that you've had of doing that leading up to that point. I think it highly unlikely that your first taste of cross-examination will be in an international case. And that's why, if that's where you want to go, honing your skills at a domestic level is important, starting off at the bottom in the magistrates court in the UK and working your way up. Developing your skills as an advocate is really important, because if at a certain point you ultimately want to be on your feet in an international case, having done all the hard work there, you're in a position where counsel will feel comfortable handing it over to you to make submissions or to cross-examine a witness. Now, on a practical level, as has been mentioned, international cases move at a glacial pace, which is why I balance that work with my domestic practice. I can have time on papers when I need to draft, and then attend hearings in The Hague when required. Remote working was already a big part of international cases beforehand, but now more so than ever, people are so familiar with using Zoom, with using other features, that it means that there's a lot more flexibility in terms of you being able to work from where you are, which means you can continue developing your practice and honing the key skills that you need, while also being able to keep a toe in the water. It's that flexibility that means that you don't need to commit everything you have to ICL when you're starting out as a junior practitioner. You can balance it with other areas of work. And particularly from an income perspective, that's important because it means that you have different streams of revenue. But connections with others and also actively seeking out work is a big part of developing a practice. While chambers can assist you to a certain extent, you have to be willing to put yourself out there and really graft. I started off at a chambers that didn't do a lot of international work, but I worked hard and with the support of my senior clerk and my head of chambers to put myself out there and to promote myself, because that was ultimately what I wanted to do. It's not just about connections as well. There's other things that you can do by yourself. For instance, writing book chapters or commentaries or assisting others with papers, forging those connections with academics and getting your name out there. It has the opportunity of not only demonstrating the fact that you understand the law and you're familiar with it, but also just promoting yourself. For instance, there was a paper that I published, and as a result of that, other practitioners and academics were in contact with me, and I've had meetings with them since. And it means now that with that connection, if something arises, I can reach out to them or they can reach out to me. I've managed to sustain my practice in this way by having this balance, and I'd like to think it's going well. In terms of opportunities that are out there, as I said, I had many, many rejections, and it is difficult. And it's right that there are less and less opportunities out there to do casework. With the IRMCT almost at an end, the STL and the ECCC on their way out, and the ICC moving at a glacial pace, the new hope is really the Kosovo Tribunal. But even that will take time to get up and running so that there are positions. It just means that there's more competition for fewer roles, which will make it a little bit tougher. But previous experience in the field remains key, and it's not just for your CV, but also to allow you to find out what you're most interested in and whether it is something that you want to do. I have friends who thought that it was their passion on the masters, but then afterwards, after they dipped their toe in the water, they realised that actually it wasn't really for them. And I've certainly learned from experience that there's a massive difference between what I thought I'd like in theory and then actually doing it in practice. One big challenge is the funding of unpaid internships. And unfortunately, many of the internships, particularly with defence teams, are unpaid. But positively and increasingly, there's a number of opportunities for funding, particularly from the Inns of Courts and other organisations to assist. However, that may not always be enough. One of the positives, if I could say that, from the COVID-19 pandemic is that everyone is far more used to working remotely. And increasingly, there's a bigger scope for part-time remote working in this field or on an ad hoc basis, whether that be as a research assistant or remote working assisting a team, which will allow you to balance the practical realities of life with gaining experience. As you saw from me, I applied for a role that I certainly wasn't qualified for. Don't be afraid to reach out to people to ask if they need assistance, particularly when it comes to points of research or those kind of matters, because 9 times out of 10, it's likely that any assistance will be welcomed with open arms. There are still opportunities out there. At the ICC, internships are offered by the OTP and also by Chambers, and some of those are remunerated as I understand it. Now, even if your heart is really with the defence, for example, those experiences will be invaluable because you get to see things from a different perspective. Closer to home, there are internships and other roles offered by the International Bar Association and other NGOs and compliance groups with a focus on international criminal law, be that policy work or lobbying. There's also mooting at an international level, which is a great way to boost your CV and also give you a real flavour, particularly the ICC moot of the Rome Statute in practice and grappling with those issues. It also means that you'll make connections not only with the participants, but also the people who are involved in it, such as the judges and the other assistance that's provided from other practitioners. As I said, another great way is by writing papers and contributing to books, blogs on issues connected to ICL. It's a great way to get your name out there. And it's also an amazing way to meet people who also have similar interests and to bounce off them as well. There are also so many different roles that you can play in this area. It's not just prosecution or defence counsel. Always bear that in mind. Investigation, translation, there are so many different areas that people can get into. And the skills, for instance, if you do a position with an investigator, for example, that's transferable if your heart really lies in being counsel. Don't have tunnel vision and think that I only can do internships or experience which is directly linked to what I want to do. Because at the end of the day, just getting your toe in the water, making those connections is something that will last a lifetime. So by way of conclusion, I echo what Howard said, that the next generation will have to grapple with many of the issues looming on the horizon. I'm someone that has had many rejections, watches Keeping Up with the Kardashians, but I got my head down and I backed myself to the point where I can now call myself a junior ICL practitioner. So as Elle Wood said, always have faith in yourself. Thank you.
Thank you very much. I'm finishing with a quote from Elle Woods, and having throughout these talks, having had Lord Bingham, it's certainly quite a range that we're covering. I'm going to turn off my video now, just because the connection is a little unstable, and turn to Q&A. And thank you, those who've posted. Please do keep posting. So the first question, please, if I may, is one for Sir Howard, and it's specifically for you, and it's in the Q&A, so you can read it, but I'll read it out. It is: how would members of a Judicial Appointments Commission be selected / appointed in order to ensure independence from the ASP?
Right. Well, I would appoint them from senior members of the judiciary of states that are members of the Assembly of States Parties, to sweeten the pill slightly. Because you are then dealing with people who are used to acting, as Fergal said, as being independent of government. And more importantly, they know the types of skills, or the skill set that is required or are required for people to be able to successfully discharge the functions of a senior criminal court complex, which is what the ICC is. So yes, I mean, essentially it would be either serving or recently retired senior judges, Court of Appeal judges from a mixture of states, both from common law and civil law jurisdictions.
Thank you very much. If I can go to some of the other questions, please, and this is one I can open up, and this is from Professor Errol Mendes, where he sets out that in his own work and research, he's become convinced that the cause of international justice has been severely diminished and ignored due to the failure of international law and lawyers to contest the right of states to claim sovereignty. And so that claim then they consider entitles them to do whatever they want to their own citizens. He sets out that it's reinforced by the UN Charter, the UN agencies, and some international tribunals and courts. And he's asking for comments. He says we need to reconstruct for the 21st century what sovereignty actually means. And this also touches upon these part of the talk by Fergal, where we had perhaps some of our own direct experience on compliance with international law, or in a limited and purposeful way by the Parliament of England and Wales specifically. So perhaps, Fergal, if I can ask you to comment on that. How do we reconstruct sovereignty? And can I just sort of meld into there an additional question about the international, about the Security Council and the veto waiving states within that? Is that now beyond time that that is reformed? And if so, how would you propose that it's done? So perhaps if we could start with you, Fergal, and then come on to Howard. Thank you.
Sure. Well, you know, one of the strengths of the Rome Statute system is that states voluntarily grant criminal jurisdiction to the ICC the minute they sign and ratify the Rome Statute. So they are voluntarily surrendering, if you like, a little piece of their own sovereignty. They still, the concept of complementarity means that the state reserves the right to genuinely investigate or genuinely prosecute the crimes at issue, and if it does so, of course, the court has no jurisdiction whatsoever. That's been a foundational principle of the statute. So as far as I can see, the Rome Statute is a great triumph, really, in the battle to ensure that states are not at liberty to commit whatever crimes they want against persons who happen to be on their own territory. And I think certainly on the jurisdictional issue, I haven't read a single judgment of the ICC which oversteps the jurisdictional boundaries which the states parties have voluntarily signed up to. On the UN Security Council point, I think it's very widely accepted that the post-Second World War bargain, where the 5 states, which are now the five permanent members of the Security Council, have a veto. I think it's widely accepted that that is now somewhat outdated. We're in 2021. What is not clear is what exactly the road ahead consists of. Which particular states should be included as permanent members in the future is one issue. Should permanent members continue to have a sole veto right, which is to say that a single state can veto a decision of the Council? Should a single state on the Security Council veto a provision which has drawn the support of over 2/3 of the members of the UN General Assembly? Should that continue to be the position? And I think there's a widespread feeling that, yes, of course, it is time for Security Council reform, but I don't see myself that there's any real prospect of Security Council reform in the immediate future. The Security Council is currently deadlocked on so many different issues due to the veto issue. So we're going to have to look again, in my view, at the duty and the obligation of the UN General Assembly to step in on matters of international peace and security, because the General Assembly does have a role on this under the UN Charter. But it's certainly a difficult issue, but it's definitely an important one. Thank you very much.
Thank you. Howard, I'm just going to add to what Fergal has said there, a comment in relation to a country I know very well, which is Colombia. And there's been a preliminary examination since around 2004. Yeah. And the triumph of the Rome Statute that the state cannot do whatever it wishes to its citizens could be argued, looking at what's happened in the recent national strike in Colombia, not to be an example of it not being a triumph at all. There's been shootings of protesters with live fire in Cali, for example, and yet the investigation still rumbles along in the background by the ICC. So can I bring you back to that question on sovereignty? And there perhaps is one example of perhaps the ICC and the Rome Statute not being such a triumph.
Yeah, well, I would agree with that. It's all situations, all the ICC situations have to a greater or lesser extent had fractious histories, largely dominated by the lack of cooperation, sometimes made more problematic by claims of sovereignty or claims of abuse of sovereignty. My experience has been that in most cases where sovereignty is raised as an anti-ICC concept or a reason for not joining the Assembly of States Parties, it's because of a misapplication of what sovereignty really is, or a misunderstanding, and a complete misunderstanding of the complementarity provisions of the Rome Statute. If people really read and understood what the complementarity provisions meant, they would see there was no threat to sovereignty, even the sort of expanded concepts of sovereignty that some rabid nationalists cling to. I think the Lauterpacht was of the view that international law was necessary because it was there to prevent abuses of sovereign authority, particularly human rights abuses against citizens of a country. I think there's a lot in that. I think it's a check and balance, but you will see people claiming sovereignty or the right to sovereignty as simply to underscore whatever particular nationalistic beef they have. I mean, we saw it in Brexit, for instance. You know, we've got our sovereignty back. What sovereignty did we actually lose? We were, you know, we weren't in a common currency. We were still had complete control over our foreign policy. We still had complete control over our defense of the nation. It's very hard to see. But nationalism and sovereignty, I'm afraid, claims thereof go hand in hand. As far as the UN Security Council is concerned, I entirely agree with Fergal. During the post-Second World War, particularly the Cold War period, power of veto was useful. Now it's probably more systematic of abuse than it is of progress, but it's very easy to give somebody a power of veto. It's very difficult to take it away from them.
Thank you very much. And Howard, whilst I have you in my sights, I'm going to bring another question your way. And this is from Thomas Verfus. And he is looking at the issue of the definition of ecocide. And you've referred to the definition that has been presented recently, with one of the drafters being Philippe Sands, and just skimming through it, no disrespect to Thomas, he's looking at recklessness, and he then comes to focus on companies, in fact, which is quite interesting. He's saying the big companies don't destroy the environment on purpose, they just want to make profit and don't care. How could the mens rea element of ecocide be defined in a way that fits well into the Rome Statute system? So that's one for you, Howard.
Thank you, Thomas. That's an easy question. Yeah, I suppose you would have to incorporate some measure of recklessness into it. It is unlikely in most cases that people are doing stuff which is environmentally damaging on purpose. It is a consequence of what they do. The primary purpose is to, for instance, extract oil, get timber, whatever it is. But if you do so in a way which is going to cause, or is likely to cause, the sort of damage which we've seen from oil spills, from over deforestation, then at the very least it's recklessness. I still think you could say that it was a deliberate act, and even if the first purpose of the act was not to destroy the environment, it was highly foreseeable that you were going to destroy the environment, or at least have an adverse effect on it. So the element really is foreseeability. And in most cases, that ought to be pretty straightforward to demonstrate. I mean, if you cut down a swathe of a forest in Brazil, which is doing two things, it's soaking up carbon dioxide and producing oxygen, and providing a unique habitat for flora and fauna, not least indigenous people. How are you going to argue against a claim of recklessness or foreseeability? I don't see that you are. I don't think this is a very. It's a nice problem to illustrate, and it's a PhD type problem. But I think in practical reality, a good prosecutor will be able to deal with it. And how does a good prosecutor deal with anything? By assembling probative, proper, relevant and admissible evidence. And if you can show that an action has caused destruction, foreseeability really oughtn't to be too much of a barrier.
Thank you. Can I also ask for questions to come through? Anything for Peta-Louise from the juniors in the audience, those who are starting off or want to start in international work, particularly international criminal work? And PL, please, I know she's hugely capable, so please do stick a hand up if you want to come in any of these questions. I'm just taking advantage of having our two particularly senior experts here at the moment, so they're taking a lot of the fire on the questions. Fergal, can I come to you on the next one, please? Both yourself and Howard have spoken about the importance of the independence of judges and also prosecutors. And the question here is, I think we all agree with that principle, and we have done obviously for many, many years, but how practically can we ensure that the judges and prosecutors in the international courts are fully independent from states and their interests, given that the states control the funding of the courts, even to the point of being able to shut down an international court through defunding when it suits them, as we've seen with the Lebanon Tribunal. And that also links to a point that was in the chat, where, again, this is from Thomas. Thank you, Thomas, you're working very hard, where he said it might be noted that there's even been an ICC judge who did not have a law degree. Quite coincidentally, that person happened to come from the state that pays the largest contribution to the ICC budget. So how these reforms have been well mooted, but nothing seems to change.
Well, on the question of how do you pick the right judges in a less politicized way, I think Howard's suggestion is absolutely excellent. And I think the appointment, we have judicial appointment bodies in our own countries. They carry out reputational interviews with other counsel that the person might have appeared as counsel, or if they're a judge, with other judges. And you know, they really get to grips with, has this person the character and the temperament to execute their judicial functions on the basis of the law and facts and nothing else. I think it's a very good suggestion. I think it should be pushed harder. Now, the independent expert report, which is currently being looked at the ICC, also makes quite strong criticism of the existing method of appointing judges at the ICC. So I certainly hope that the appointment process for judges does improve in the future. Now, when it comes to funding, the two things to keep in mind here. First of all, judicial decisions should not depend on budgetary issues, but at the same time, judges and prosecutors, and in my view, defense lawyers, we all have a collective responsibility to ensure that criminal proceedings are run efficiently and fairly. By efficiently, I mean relatively expeditiously, that we don't end up with enormous delay. And I'm not seeking to put blame on any particular group of people, but I think it's a collective responsibility to use the funds which you are given by the international taxpayer in an efficient way. So I think that's vital. So there has to be a dialogue with states parties, because at the end of the day, states parties are going back to their national treasuries and they're asking for money to spend on international justice, which could be spent on hospitals or schools at home. So we have to be very realistic about that. But in terms of ensuring that judges and prosecutors are fully independent, it's ultimately down to character. You have to hire the right people. You have to hire people who have the strength of character to withstand political pressure and to understand fully how to execute their functions, which comes from experience, how to execute their functions in complete adherence with the statutory requirements of independence and impartiality.
Thank you. Howard, if I could ask you briefly, and then PL, I'm going to come to you with a final question, if I may. But Howard, could you, any comments on the report, it's in our Q&A on the current report that's being considered that Fergal's just referred to, plus how do you actually realistically depoliticize the ICC when it is effectively a political body? So it's the ICC expert review report was asked to have any comments on. And we actually have a specific question for you, PL, and I'll add to it. How did you gloss over the fact that you didn't speak Serbo-Bosnian in your application? So Howard, over to you, please. Any other comments on that reform aspect, please?
Well, the independent expert review was a very necessary exercise, and I actually gave quite a long submission to it. You'll not be surprised to know that most of my submission was based upon the selection of judges. Whether I thought it had reached fertile ground, but now I'm not sure. But the short answer is you cannot depoliticize any international institution, whether it's the Food and Agriculture, whether it's UNICEF, whether it's ICTY, ICTR, ICC. Politics is the, as it were, the nerve endings that go through the body corporate for all of these institutions and virtually any international institution. So accepting that as a given, you revert back to what Fergal was talking about, of having judges who are scrupulously independent, who will not allow any form of political interference, either from the state which nominated them or indeed from any other state, and have one thing at the forefront of their minds. And frankly, it's the thing that's always been at the forefront of my mind. Am I being fair? Am I treating people who come before the court, whether they're the prosecutor, the defendant, the victims, are they getting a fair hearing? Because it is the duty of a judge, as it is a referee, if you like, to provide a fair forum and to be as fair as human wit can engender. And part and parcel of being fair is to not allow extraneous matters such as politics to interfere with your decision. In court, the only thing that matters is the quality and consequence of the evidence that judges hear, either on trial or appeal. If you can't cope with that, you're in the wrong job. It's as simple as that.
Thank you very much. And PL, we have two questions for you now. One is, to what extent is it necessary for budding ICL practitioners to be licensed or to practice in a country, as opposed to merely having as opposed to having obtained a law degree and masters? It's not merely, particularly when it can be expensive to qualify in some countries. And then there was the specific question about your application.
I'll take the question about my application first. What I did was effectively frame my entire application form around the other skills and competencies that they required. So focusing on, particularly, they asked about drafting, they asked about teamwork, they asked about leadership. So I focused on all the things that I could do, as opposed to mentioning the fact that I couldn't speak BCS, because it was perfectly apparent from my application form that I couldn't. I obviously wasn't going to lie. So I left it at that without directly saying I don't speak it. It was just apparent. And I think sometimes when you're thinking about application forms, they're a written piece of advocacy. And that was very much in my mind when I was filling it in, is what I can bring to the table as opposed to what I can't, and hoping that they would see that. And thankfully they did. And it meant that that started sort of my career in ICL, really. And then to the second question, about whether it's necessary to be licensed to practice in a country. Ultimately, it really depends on what you want to do. And I say that because I know people who've paid for the bar course, for example, and then have decided that actually they don't really want to practice necessarily in ICL, they want to play a different role. So it's about figuring out what you actually want to do and then making an informed decision about whether you need to be licensed to be able to do what you need to do. A good way of thinking about it is having a look at the application forms at the ICC and the other courts and tribunals for legal assistance and for the list of counsel, and seeing what they require and thinking, is that the role that I want to play? And if it is, maybe this is something I need to do. I think particularly with ICL, given that it's expensive to do unpaid internships, it's expensive to go through all the training if it necessarily later on that's not something you want to do, is to really pause and just think about what you enjoy and what you like about it. I have a friend who was a practitioner in another country and thought that that was what he would want to do in international law, but now works in more policy and works in that area and absolutely adores it. So that's why getting the experience and getting your toe in the water and just speaking to people who do that kind of work will really help inform how you move forwards. because what you don't want to do, as you've mentioned, is sort of go through the expense of qualifying and then realizing it's not viable or that's not actually what I want to do, if that's the sole reason why you've sort of got that qualification. So taking your time would be my advice.
Thank you very much. I'm going to give a summary. Those of you who have only just joined or wondering why there's no face to me, I'm in a slightly unstable internet location, and so I've turned my camera off. I'm not usually so shy at having my face out there. But in summary, a fascinating discussion. Thank you so much to the whole panel, and thank you so much to everybody who has posted questions. What's come through from everybody has been that there needs to be a reform of the system of appointment of judges, that there must be a fundamental requirement of adequate expertise and adequate experience in order to perform that role. It might seem very basic, but it is still a matter that is being considered. Our judges need to be independent of the governments and of the states. Again, another matter that is being grappled with. Howard in particular has looked at the future and has looked towards the challenges from climate change, with water as one of his central points, as what he has spoken about, that conflicts are increasingly going to occur over the availability or scarcity of water. And then obviously we have the issue of overpopulation. And from there, both Howard and Fergal have also commented on the crimes under the Rome Statute, and looking ahead towards an ecocide crime and looking at incorporating of recklessness within there. Fergal has also spoken about the ICC in a broader way and looking at it as being a marker of a fact-finding and recognition of atrocities that have occurred, and therefore being important to historic memory. And both Howard and Fergal have spoken as to perhaps sometimes a misunderstanding or misuse of the word sovereignty, and in fact that state parties have to some degree ceded some sovereignty in becoming a state party to the Rome Statute. Fergal's given us some positive news, if those in our audience and we didn't know already, concerning the US relationship, the USA relationship with the ICC, that is improved post the new administration with President Biden, and that the previous orders by Trump have been rescinded by Biden. We have the issues of lack of use, perhaps, of dispute mechanisms which are within the Rome Statute, and so where we see a standoff with states not accepting jurisdiction, Fergal in particular has considered that is unacceptable. They're a state party and there are dispute mechanisms within the Rome Statute which are there to be used. Peta-Louise Bagott in particular has spoken of her own specific experience and application after application, because of her own interest in working in ICL and in international law, and being ready to take the rejections and the knockbacks. And I can certainly add my own voice to that. I'm sure there's nobody on this panel as well who hasn't had a huge amount of knockbacks. It really does happen to all. She's also spoken about applying and actually getting a position through applying for a position that she said she wasn't qualified for. I probably gently correct, she probably was extremely well qualified, apart from in one sector, which was the language. And there are some interesting statistics out there that in fact the majority of applicants are not fully qualified in these applications. Quite often they are lacking in one particular section, and there's some really fascinating statistics that it tends to be the men that push through with those applications and the women who are put off if they are not 100% tick boxing on the requirements. So please everyone bear that in mind and have confidence in those applications, because you might find yourself then referred on to something you have thought about. The difference perhaps between studying and between your own thoughts as to what you think you might want to do and the reality of it, and to bear that in mind, that it might simply be that international law ICL isn't actually where your passion lies when you get there, and there is absolutely nothing wrong with that in keeping your mind open. The state parties with grievances, I probably should just emphasize Fergal's point coming through, that grievances from state parties should be aired through the structure of the Rome Statute, and also the requirement for non-discrimination outside high-level statements that we do have a lot of. But overall, the panel is ultimately saying, probably, if I may summarize, that if we didn't have an ICC now, we would undoubtedly all be sitting here in our respective places around the world and all listening in and advocating for an ICC. And so we are in a good position. We have one which is reasonably established, but it certainly does need reform, and everybody agrees with that. And Peta-Louise also has referred to the glacial pace at which it moves. The cases take so long, and there also is a lack of coherence in judgments currently, perhaps going back to the issue of the judges who have historically been appointed. So in summary, it's there for good, and it needs reform, it needs resources, it's a court to get behind, and ultimately, if I may borrow Howard's closing points, that ultimately it is a matter for the young junior lawyers, those with ideas, those who are joining in perhaps today, and those of you who know others who are interested, to try and push on with this reform and keep states accountable for atrocities, and hopefully also act as a preventative measure and a deterrent to those atrocities happening in the first place. Thank you everybody for joining. I am going to close now, but with again, congratulations and to Sir Howard Morrison and Fergal Gaynor. I will say congratulations for joining Doughty Street, but ultimately we obviously are absolutely privileged to have you as our associate tenants. And I know I speak for all of Chambers in welcoming you and thanking all for giving up their time, particularly on a Saturday, and I believe it's very hot in the UK, on a hot day, to join in this important discussion. Thank you.